Welcome to Chapter 13. After our world tour of transfers, we return to a question that logically comes first, but teaches best now that you know what's at stake. Who and what does the GDPR actually govern? Here's today's agenda. We begin with territorial scope and its two arms. The establishment criterion of Article 3.1, which catches organizations with a presence in the EU, and we'll see how loosely presence can be defined thanks to the Google Spain case. Then, the targeting criterion of Article 3.2, the long arm that reaches companies with no EU presence at all, the moment they offer goods or services to people in the Union or monitor their behavior. Next, the EDPB's guidelines that keep these tests honest, including the Article 27 representative requirement and a reality check on how extraterritorial enforcement actually works. Then we switch from where to what, material scope. Which processing activities are covered, automated versus manual, and what a filing system means. And we close with the exemptions, the famous household exemption and its surprisingly sharp edges, plus the carve-outs for law enforcement, national security, and EU institutions, each governed by its own instrument. Why does scope matter so much? Because it's the first question of every analysis. Before asking, is this lawful, you must ask, does this law even apply? Let's sharpen that first question. Let's start with the GDPR's first jurisdictional arm, the establishment criterion. Article 3.1 says, the regulation applies to processing in the context of the activities of an establishment of a controller or processor in the Union, and here's the kicker, regardless of whether the processing itself takes place in the Union. Two phrases in that sentence do enormous work, so let's take them apart. First, establishment. The recitals define it as the effective and real exercise of activity through stable arrangements, and immediately add that legal form is irrelevant. No incorporated subsidiary needed. A branch office counts. A sales team counts. In some circumstances, even a single representative with a desk and a lasting presence can count. The test is substance. Is the organization really, stably doing something here? Second, and this is the phrase that changed internet law, in the context of the activities. The processing doesn't need to be performed by the EU establishment. It merely needs to happen in the context of its activities. Enter the Google Spain case. Google's search engine was operated entirely from the United States. Its Spanish subsidiary did nothing but sell advertising. Google argued the search processing was therefore outside European law. The Court of Justice disagreed with the reasoning that still echoes. The ad sales financed the search engine, making the two inextricably linked. So the search processing occurred in the context of the Spanish establishment's activities. American servers, Spanish jurisdiction. Feel the breadth of that holding. A non-EU company with any EU commercial presence connected to its data processing likely falls within scope through this door alone. And note the final clause once more. Where the processing happens is irrelevant. Servers in California, analysts in Singapore, if the context is an EU establishment, the GDPR applies to it all. That's arm number one. Arm number two reaches even further. Now for the long arm, the targeting criterion. Article 3.2 captures controllers and processors not established in the Union at all, based purely on what they do to people located here. Two triggers, and each rewards close reading. Trigger 1. Offering goods or services to data subjects in the Union, and the recital adds irrespective of whether payment is required, so free apps and free platforms are fully caught. The operative word is offering, which implies intention. The recitals guide the analysis. Mere accessibility of a website from Europe is not enough. Otherwise, every web page on earth would be regulated. Instead, look for evidence the business envisages European customers. Does it offer EU languages that aren't its home language? Prices in euros? Delivery to member states? Testimonials from European users? A country-specific domain? Each factor is a fingerprint of intent. Picture two online shops. A boutique in Osaka, Japanese language, yen only, ships domestically. A Parisian happens to order via a forwarding service, not targeting, not in scope. An American retailer with a French language site, euro prices, and shipping to Europe, targeting, in scope, no EU office required. Trigger 2. Monitoring the behavior of data subjects as far as their behavior takes place within the Union. The recitals point to tracking individuals online, profiling them to analyze or predict preferences, behaviors, and attitudes. Translation for the modern web: cookies following browsing habits, analytics building visitor profiles, ad tech auctioning attention, fitness apps logging locations. A non-EU ad tech company that has never sold a thing to a European but tracks European users across websites is squarely within scope through this trigger. Notice the elegant common thread. Both triggers protect data subjects who are in the Union. Residence and citizenship are irrelevant. Presence is what counts. An American tourist browsing in Berlin is protected. A French citizen living permanently in Brazil generally isn't. The law follows people on European soil, not passports. The two criteria give us the skeleton, and the EDPB's Guidelines 3/2018 supply the judgment, the worked examples and boundary lines that turn Article 3 into something you can actually apply. Let me share the clarifications that matter most. First, targeting requires more than contact. The guidelines hammer the recital's point: a website merely reachable from Europe, an email address, a phone number, none of that alone establishes targeting. The assessment is holistic. Gather the fingerprints of intent we discussed: languages, currencies, delivery, marketing orientation, and weigh them together. One factor rarely decides, the pattern does. Second, the criteria attach to processing activities, not to organizations wholesale. A company might be in scope for one activity and out of scope for another. Think of a non-EU retailer targeting European customers for its online store. In scope for that, while its purely domestic employee payroll stays outside. Precision matters. Scope is analyzed operation by operation. Third, and here's the clarification exam writers love: the processor question. If a non-EU processor serves an EU controller, does the GDPR bind the processor directly through Article 3.1? Not automatically. The processor isn't in scope merely because its client is. But the controller's Article 28 obligations mean the protection arrives contractually anyway, and the processor may independently fall in scope through its own establishment or targeting. Fourth, the practical anchor, Article 27. Organizations caught by the targeting criterion without any EU establishment must designate a representative in the Union, in writing, located in a member state where their data subjects are, serving as the address for supervisory authorities and individuals alike. Exemptions exist for occasional, low-risk processing and for public bodies. And a nuance worth remembering: the representative is a contact point and can face enforcement, but designating one does not transfer the controller's liability. The foreign company remains fully answerable. The representative is the doorbell, not the defendant-in-chief. Scope on paper is one thing. Let's talk about the honest question everyone eventually asks. Can Europe actually enforce its law against a company on the other side of the planet? The formal toolkit first. Supervisory authorities can investigate, order compliance, and fine any organization within Article 3 scope wherever incorporated. The Article 27 representative provides a practical anchor inside the Union. Documents can be served, questions can be directed, presence is manufactured. And authorities cooperate internationally. Article 50 encourages mutual assistance with third country regulators, and privacy authorities worldwide increasingly coordinate investigations. Now, the honest limits. A company with no EU establishment, no EU assets, and no appointed representative presents a genuine enforcement puzzle. A fine issued in Europe must still be collected somewhere. Cross-border judgment enforcement is slow, uncertain, and dependent on the other country's courts. Some deliberately non-compliant operations simply ignore European letters and everyone in the field knows it. But, and this is the insight that makes the extraterritorial design work anyway, formal enforcement is only one lever among several. Market access is the quiet giant. A business that wants European customers, European advertisers, European App Store presence, or European partners cannot afford pariah status. Payment processors, platforms, and B2B clients increasingly demand GDPR compliance contractually. The market enforces what regulators cannot reach. Reputation compounds this. Privacy scandals travel instantly, and enterprise procurement teams read the news. And observe the strategic endgame, the Brussels effect. Faced with the choice between running separate data regimes or lifting everything to the strictest standard, many global companies simply applied GDPR-grade practices worldwide. European law becomes the de facto global baseline not through courtrooms but through corporate architecture. When you see a privacy notice in Nairobi or Sao Paulo that reads suspiciously like Article 13, you're watching extraterritoriality succeed by osmosis. Jurisdiction on paper, gravity in practice. We've settled where the GDPR applies. Now the companion question. What activities does it cover? That's material scope, Article 2. And it has a two-part answer with a vintage story behind it. Part 1. The regulation applies to the processing of personal data wholly or partly by automated means. Given how broadly processing is defined, collection, recording, organization, storage, adaptation, retrieval, use, disclosure, erasure, practically anything you can do to data, and given that automated means covers every computer, phone, and server on Earth, Part 1 alone captures essentially all modern data activity. If it touches a processor chip, it's in. Part 2 handles the paper world, and here's where precision pays. Manual processing is covered only when the data forms part of a filing system or is intended to. A filing system means a structured set of personal data accessible according to specific criteria. Picture the difference. An HR department's alphabetized personnel files in a cabinet, structured, retrievable by name, that's a filing system, fully covered. A cardboard box of unsorted meeting notes in a storage room. Personal data may lurk inside, but with no structure enabling retrieval by criteria, it's outside material scope. The logic is risk-based. Structure is what makes paper data findable, usable, and therefore dangerous. Chaos is its own protection. The Court of Justice tested this in the Jehovah's Witnesses case. Door-to-door preaching notes about residents kept to organize return visits. Handwritten, informal, spread among members, yet organized by geography and retrievable, the court found a filing system. Structure can be humble and still count. And two clean exclusions complete the picture, both flowing from definitions you already own. Anonymous data, truly irreversible, sits outside scope entirely. No person, no personal data. And data about the deceased is excluded, though member states may legislate their own protections. And beware the ricochet. Records about the dead often reveal information about the living. Hereditary conditions in a medical file, for instance, which snaps those elements back into scope. Now for the exemption everyone has heard of and most people overstate, the household exemption. Article 2(2)(c) excludes processing by a natural person in the course of a purely personal or household activity. It's the reason your phone's contact list, your family photo archive, and your holiday group chat don't make you a regulated data controller. The law has no ambition to audit birthday party invitations. But the operative word is purely, and the case law has sharpened it into a blade. Two boundaries define the exemption's edges, and both are exam gold. Boundary 1. Audience. The Lindquist case set it early. A churchgoer published colleagues' names, activities, and a health detail on a publicly accessible web page. Personal hobby project? The court said no. Making data accessible to an indefinite number of people leaves the personal sphere. The same logic governs social media today. A private family album shared with relatives sits comfortably in the exemption. A public account broadcasting identifiable others to the world does not. Boundary 2. Territory, literally. In the Rinesh case, a Czech homeowner, plagued by vandalism, mounted a camera that recorded not only his house, but the public street and a neighbor's entrance. The footage helped identify suspects, and the suspects challenged the processing. The court held that surveillance extending beyond the private setting, even partly, into public space, cannot be purely personal or household activity. Your camera watching your own hallway? Exempt. The same camera sweeping the pavement, you've become a data controller with obligations to strangers walking past. Every video doorbell owner in Europe lives on this exact line, mostly without knowing it. One final asymmetry that catches people. The exemption shields the individual, never the infrastructure. You posting on a platform may be exempt. The platform processing your post is fully regulated. Recital 18 says it plainly. Controllers and processors providing the means for personal processing remain covered. The household is a shelter for persons, not for businesses standing behind them. Let's complete the scope map with the remaining exclusions, and the key insight here isn't that protection disappears in these zones, it's that different instruments take over. Think of it as jurisdictional handoffs, not gaps. Handoff 1. Law enforcement. When competent authorities process personal data for preventing, investigating, detecting, or prosecuting criminal offenses or executing penalties, the GDPR steps aside and the Law Enforcement Directive, Directive 2016/680, steps in. The LED is the GDPR's stricter context sibling. Same principles, adapted machinery, distinctions between suspects, victims, and witnesses, logging requirements, rules on transfers between police forces. The dividing line runs through function, not institution. A police force investigating a burglary operates under the LED. The same force processing its own employees' payroll operates under the GDPR. One building, two regimes, sorted by purpose. Handoff 2. National security. Activities concerning national security fall outside EU law entirely. Member states kept that sovereignty. So neither the GDPR nor the LED reaches intelligence services' core work. But outside EU law does not mean outside all law. The European Convention on Human Rights still applies, and the Strasbourg Court has built rich case law disciplining surveillance. The same jurisprudence, you'll recall, that feeds the European essential guarantees used in transfer assessments. The circle closes neatly. Handoff 3. The EU's own institutions. The Commission, Parliament, and agencies process data under Regulation 2018/1725, a mirror of the GDPR, supervised by the EDPS, whom you'll meet properly in Chapter 16. Add the exclusion for activities under the Common Foreign and Security Policy and the household exemption from last slide, and Article 2's map is complete. Here's the exam skill this all builds. Instrument identification. A scenario describes processing, and before analyzing any obligation, you silently ask, which regime governs this? Police investigation, LED, spy agency, national law plus ECHR, EU agency, the 2018 regulation. Everything else with personal data and structure are familiar GDPR. First question first, always. And that scope conquered. You can now do what every analysis demands first. Determine whether and how the GDPR applies. Establishment and targeting, the representative requirement. Filing systems, the household exemptions' sharp edges, and the handoffs to the LED and beyond. It's the gatekeeper skill, and you've got the keys. Quick checkpoint as always. If this series keeps proving its worth, hit subscribe. It unlocks this playlist plus all our other certification playlists, and it directly supports more free structured training reaching this community. Keep the sequence intact too. Next chapter, we move from whether the GDPR applies to how organizations prove they're honoring it, the accountability chapter. Data protection by design and by default. records of processing, and the complete DPIA methodology, the documents and disciplines regulators ask for by name. Today's scope skills feed straight in. You can't document processing you haven't first located and classified. And when you're ready to drill, our complete CIPP/E course on Udemy carries the full practice arsenal, chapter quizzes, realistic full-length practice exams, role-play scenarios like advising a non-EU startup on whether Article 27 catches them, and downloadable revision toolkits. Link in the description below. Take a short break, and here's your walkaway self-test. Explain in one sentence each why Google Spain was in scope and why the Rinesh camera lost the household exemption. Then meet me in chapter 14. See you there.